Following the signing into law of the Expropriation Act by the President of the country, the Democratic Alliance has raised its grievances. Today, the leader of the Democratic Alliance, John Steenhuisen, speaking to the media, had mentioned that the DA will approach the GNU Clearinghouse Committee chaired by Deputy President Paul Mashatile, as they have now invoked Clause 19.3 in particular of the Statement of Intent that binds the GNU member parties together. In the very same statement, John Steenhuisen had also mentioned that he carries no faith in the Clearinghouse Committee, as it has become a mechanism which has been abused and has no clear terms of references. Meanwhile, the ANC, during its Lekgotla taking place in the east of Johannesburg, has said that it supports the signing of the expropriation bill into law, the act now, and believes that this will decrease the exacerbation of the problems of landlessness, but more importantly, stimulate transformation in South Africa. Let's speak now to Professor Bheki Mngomezulu, who's a political analyst. Prof, does the DA have cause for concern in the Clearinghouse Committee and the political maturity of the ANC in engaging their dispute?
Thank you very much for having me, and good evening to your viewers. First of all, we must understand what happens when no party won the election with an outright majority. This is the situation we find ourselves in, where we have a multi-party coalition which is led by the ANC by virtue of the fact that it got the highest number of votes. But then the question then becomes, how do you maintain this coalition? What are the terms of reference, like introductory comments indicating that there is a specific section 19.3 which the EDA is citing? Were the ANC aware of that section when the president invoked section 84 of the Constitution and signed the bill into law? If then the answer is in the affirmative, well and good, the DA has no case. But then if the president or the ANC, as part of this coalition government, passed some of the sections without necessarily delving into them and then abiding by them, then of course the DA will have a case to present to the ANC, and the ANC will have to answer to that. So we just have to understand what was agreed upon and what has the president done wrongly, which deviates from section 84, which empowers him to sign these bills into law, appoint and fire ministers, as the case might be.
Yeah, the Democratic Alliance seems to be of the opinion that the international community believes so much in the GNU, specifically because the DA is a part of it and all that the DA stands for. Does the Expropriation Act go against the sentiment that the DA seems to purport to that to be of the international investor community and the renewed belief in South Africa as they just returned from Davos?
There are two issues, my brother, in answering your question. One is, we have a constitution for South Africa, not the constitution for the globe. Each and every country has its own constitution. Therefore, the powers that reside with the president of South Africa are the powers that should be exercised by the president of South Africa. That is point number one. But then point number two, if indeed this act, there is something wrong with the act, South Africans in general and then political parties that are part of the coalition have to basically raise those concerns with the ANC, and then the ANC will have to reason with them. But my main concern, to be honest with you, is that I don't see how this new act in fact deviates from section 25 subsection 2 of the current constitution in terms of the expropriation of land without compensation, because that section is clear that you cannot just willy-nilly expropriate land. All you do is you approach the person who is owning the land, you negotiate with that person, and then you try to find each other, and then if there is a settlement, to settle. Only if then that does not happen, to then go to the next step of expropriation. So I don't know then what the difference is with the current one, which is then the reason why I also have a question as to why the DA is having an issue with this act and did not have an issue with section 25 as it stands.
Yeah, let's speak about that, because like you argue, and many legal scholars agree with you here, is that the Expropriation Act merely gives expression to the limitations that Section 25 brings about in terms of when expropriation without compensation in particular can take place, and it describes it as null compensation. 5 scenarios, it says. It can expropriate abandoned land, land held for speculative purposes, state-owned land not in use for its core function, land posing health and safety risks, as well as underutilizing land for public benefit. Do those 5 null scenarios, null compensation scenarios, exclude compensation with expropriation without compensation so much that we won't actually see land reform take place under the dispensation of the Expropriation Act?
You know, my brother, let us be honest here. South Africa is very good when it comes to passing legislation or enacting law. It's also very good when it comes to formulating policies. Some of our policies, in fact, are so good that other countries are even using them. Our only problem is implementation, which then answers your question. Should South Africans rejoice now that we have replaced the 1975 Act with the current one? My answer is no. There is no reason to celebrate, simply because having a law does not necessarily mean that that law will be implemented. All we need is the political will from the implementers. In this case, our politicians have to be honest to themselves first, and then they must be honest to us as the electorate, because we are the ones who voted them into office. So even if you have this newly signed bill into law, it doesn't necessarily mean that our problems are over. It will take years before you reach that stage of expropriation without compensation.
Let me ask you to speculate for a second here. President Ramaphosa had signed 2 acts into law which the Democratic Alliance does not agree with, but where their ministers are responsible for the implementation of that. The Bella Act on the one hand, where the Minister of Basic Education doesn't agree with it, and the Expropriation Act, where the implementing agent in this instance is the Minister of Public Works and Infrastructure, Dean McPherson, who vehemently disagrees with it. Quite literally, he tweeted yesterday that he has no intention of expropriating land without compensation under his watch. Did the president appoint them to those positions knowing full well that he intends on signing bills into law that they disagree with, setting them up for potential failure, or setting those bills up for failure because then he can simply say the DA didn't want to implement it, it's not my fault?
One, we don't run this country through Twitter or any other social media for that matter, unless we are Donald Trump. So that is point number 1. Point number 2, Section 84 of the Constitution is clear that the sitting president, whoever that president is, you don't have to like the president, you don't have to hate the president, you just have to follow the Constitution. All those ministers and deputy ministers did not appoint themselves, nor were they appointed by their political parties. They were all appointed by the president, in this case, President Ramaphosa. So whether you like the law or not, it's neither here nor there. You just have to implement it once it has been enacted. So in this case, whether you're talking about as if you were in the Bella Act or you're talking about McPherson, it just doesn't matter. They are ministers of the current coalition government, which they call GNU for whatever reason. But the point is, once the act has been signed, then as the implementing agent, as the minister responsible for that particular ministry, we have an obligation to implement it. If you don't want to do that, then you might as well resign and then let the president appoint another person.
Yes or no? Is the coalition fragile right now?
Yes, indeed. The ANC has more reasons to learn from this, because if they had corrected some of the mistakes from 2019, 2021, we wouldn't be where we are right now. I think that they've now learned the lesson the hard way, that if you go to a coalition government which you don't understand how to maintain it, this is what you get.
Yeah,
Prof. You get resistance, and then you still have to implement it.
Yeah, we're going to have to leave it there. Thank you so much for your time. Really do appreciate it. Political analyst, Prof. Bheki Mngomezulu.